Hello friends, welcome back to our channel Legal Nexus. In today's video, we are going to discuss a very important concept in law, legal rights and duties. Rights are the benefits and freedoms that the law guarantees to individuals, while duties are the responsibility that law expects from us. In fact, right and duties are two sides of the same coin. Whenever one person enjoys a right, there is always a corresponding duty on another. Understanding this balance is essential to how law maintain order and justice in society. The law protects the legal right of every citizen. By being a citizen of country, the people are given the legal rights. It is the duty of every individual to protect the rights of each individual. Law is one of the most essential element of the society, which is responsible for the development of the state and its aim for the welfare of the state. Rights and duties have of legal significance in the society and this due to various reasons. Essential condition of legal rights. According to Salmon, there are five essential conditions that need to be fulfilled. The person of inheritance, subject of right, the subject of duty, the person of incident, contents or subject matter of legal rights, the object of legal right, title of the legal right. Classification of legal right. Right in rem, right in personam, positive right and negative rights, personal and property rights, perfect and imperfect right, right in re aliena and right in re propria, corporeal and incorporeal right, primary and sanctioning right, public and private right, vested and contingent right. Right in rem and right in personam. A right in rem is a right which is available against whole world. It is a right in respect of a thing. The correlative duty will be upon persons in general. Positive and negative right. When the corresponding duty of a right is positive, the right is called positive law. The positive duty is the duty to do something. For example, A is husband of B. By virtue of section 125 of the Code of Criminal Procedure 1973, A is under a duty to maintain his wife B. The duty of A is positive and the right of the B is positive right. Proprietary right and personal right. Right in which have economic value can be called proprietary right. Those rights which can be converted into money value can also called as proprietary right. For example, right in land, right in movables, patent right. Right which have no economic value are called personal right. For example, right and parental right. Proprietary right are generally alienable, but personal right are not alienable. Perfect right and imperfect right. A perfect right is one which is recognized and protected by law. A perfect right is one which corresponds to a perfect duty. A right which is recognized and enforced by the court of law can be called perfect right. Right in re propria and right in re aliena. Right over one's own property are called right in re propria. A person's right of ownership over a property is right in re propria. Right over another's property is called right in re aliena. Right of a lessee over lessed property. Right of a mortgagee over mortgaged property. And right of a dominant owner over servant tenant are example of right in re aliena. They are encumbrance. Public right and private right. Public rights are those rights which are vested in the state. Private rights are those rights belongs to individual members of the society. Primary rights and sanctioning right. A sanctioning right is one which arises out of a wrong. When A defamed B, B gets a right to compensate. Such a right is called a sanctioning right. A right which is not arising from a wrong of another is primary right. For example, right to reputation. Legal and equitable right. Under English law, rights could be classified into two. They are legal rights and equitable rights. Those rights which were recognized and protected by common law courts were termed as legal rights. Those rights which were recognized and protected by the court of equity were called equitable rights. After the fusion of law and equity by High Court of Judicature Act 1873, the practical importance of this distinction has came to an end in England. Theories of legal rights. There are two main theories of legal right and they are followed as will theory of legal rights. The will theory of legal rights has been advocated by Hegel, Kant, Hume. According to the will theory, a right attributes human will and it also says that the need for law resolve around the free expression of human will. It is stated that the subject matter of a legal right is influenced by human will. John Locke observed that the basic of right is the will of the individuals. This theory of legal right has been accepted widely, but however, there were many scholars who were against this theory. Dickett opposed this theory of will, as according to him, the basis of law is social solidarity and not the human will, as he observed that the purpose of law is to protect the acts or right of the citizens of the state. The second theory is interest theory of legal rights. Rudolf von Gern, a German jurist, proposed the interest theory of legal rights. He defined legal right as interests which are legally protected. His theory says that the rights are related to interest and the right to do not emphasize on human will. This theory contradicts the theory of will as it says that the basis of law is interest and not will of the people, as the main purpose of law is to protect the human interest and to resolve the conflict of interest of different people. Although this theory was supported by Salmon, he mentioned that the enforceability of law is also an essential element and he says that the right concerned with interest and indeed have defined as interest protected by rules of right that is moral or legal rights. This theory has been criticized on the ground that it is incomplete, as the theory it is completely overlooks that element of recognition. Duty is an obligation to do or omit to do something. In legal sense, duty, legal obligation means to do or not to do something. According to Salmon, a duty is an act that obligatory is to stay. It is on opposite of which would be wrong, duties and wrongs. According to Hibbert, legal duty as the predicament or a person who acts are liable to be controlled by another with the assent and assistance of the state. Kinds of duties. In duties may be classified into legal duty and moral duty, positive or negative duty, primary and secondary duty. Legal and moral duty. A legal duty is an act the opposite of which is legal wrong. It is an act recognized as duty by law and treated as such for the administration of justice. A moral or natural duty is an act the opposite of which is moral or natural wrong. A duty may be moral but not legal or legal but not moral, positive or negative duties. When the law obliges us to do an act, the duty is positive, and when the law obliges us to forbear from the doing an act, the duty is negative. Primary and secondary duty. Primary duties are those which exist per se and independently of any other duty. An example of primary duty is to forbear from causing personal injury to another. A secondary duty is that which has no independent existence but exists only for the enforcement of other duties. An example of secondary duty is the duty to pay a man damages for injury is already done to the person. So sum up, rights and duties are deeply connected. One cannot exist without the other. Rights give us freedom and protection while duties remind us of our responsibility toward others and society. By respecting both, we ensure balance, harmony, and justice in our legal system. If you found this video helpful, don't forget to like, share, and subscribe for more legal insights.